disrespect that y'all are showing to the officers, I can assume what these are going to say. I will not accept this plea agreement. I'm sick of it. The jail's sick of it. Thank you, Ms. Morfino. All right, sir, are you Camden Jackson? And Mr. Harris, will your client waive the formal reading of the indictment?
Yes, Your Honor.
Just a second. Mr. Jackson, in cause number 20, all right, y'all marked third degree on the paperwork, but the indictment says second. I just want to make sure it's marked correctly.
I just looked at it sideways.
Okay, so that should be second degree.
Yes, Your Honor.
If everybody's permission, I'll make that change on the paperwork.
Yes.
Okay.
And apologies for my handwriting because it's horrible.
It's hard on the tablet. You're good. All right, so you're charged in cause number 25 DCCR 0114 with the second degree felony offense of engaging in organized criminal activity from January 10th of 2025. And how do you plead to that charge?
Guilty.
Are you pleading guilty freely and voluntarily?
Yes, ma'am.
And are you pleading guilty because you actually did what they charged you with?
Yes, ma'am.
I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Harris?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand if I follow the agreement that you've made with the district attorney that you'll be waiving or giving up any right to appeal?
Yes, ma'am.
And it looks like the agreement that you've reached is for a 7-year deferred probation. There would be a $500 fine, and you would be required to follow all of the rules and conditions of probation, which could include me ordering you to some upfront treatment like ISF or something like that, and it looks like that's what the state's going to be requesting. Do you understand?
Yes, ma'am.
And that decision's up to me when we come back for sentencing.
Yes, ma'am.
Do you also understand, excuse me, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1.
No objection, Your Honor.
It's admitted. Is there any evidence that Mr. Jackson's not competent?
No, Your Honor.
All right, Mr. Jackson, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty. However, I'm going to restate your case so that the probation department can do a pre-sentence report. That'll give me more information about you, your case, and then we'll come back later for sentencing. Before we go forward, can you look real quick jail incident reports and see if there's any on this one?
And Judge, I was, if I may, going to address that between January and the end of February. So obviously we've had quite some time that either they have not gotten to my file or the court's file. There were at least 8 pages full of write-ups. I would ask the court, Mr. Jackson committed this offense 6 days after he turned 19. It's obviously very serious. He was with a co-defendant, Mr. Bushnell, who's already entered a plea involving firearms, etc. I would ask if the court would consider your usual admonishment of if that behavior continues pending the PSI, that I reserve the right, as does the court, to just reject this offer and possibly send him to prison.
Mr. Jackson, you're probably, I don't know if you're in the same dorm as some of the other ones that have been absolutely ridiculous acting up in the jail.
Yes.
So there's somebody, I think it was last week, that came in with a deal like this for a probation, and he didn't get it, and he's sitting back out at that jail. I do not have to accept this plea agreement. I'm going to read every single one of those jail incident reports. The disrespect that y'all are showing to the officers, I can assume what these are going to say. Because y'all are all out there, it's the same group that's doing all the same thing, fighting, not following instructions, talking back, calling names. I'm going to read all of that. And let me tell you, if you have one between right now and your sentencing, I will not accept this plea agreement. I'm sick of it, the jail's sick of it, and I'm going to do whatever I can to make that place a better place for those people to go work who are out there just trying to do their job. Do you understand? 1, We're not gonna come in and say it was somebody else's fault, I only got one, or I got three, and that's not that bad. You can go out there and tell them, I wanna get out and be on probation. I don't care what you guys wanna do. I'm gonna behave. If you have to sit on your bunk all day long and be quiet for the next 5 weeks, then that's what you do. Right? 5 weeks, rest of your life. What do you think? Show me you can do it, okay? All right, and go back with the bailiff.
Thank you, Your Honor.
Yes, sir. All right, so you're Raquel Glover, and this is cause number 24 DCCR 0232. Mr. Glover's case was set for trial a couple of weeks ago. We were about to start with jury selection. Mr. Kimmler filed a motion to quash the indictment based on some relatively new cases that have come down from the Fifth Circuit as well now from the Supreme Court with regard to underlying offenses on unlawful possession of a firearm by a felon. I have done a substantial amount of reading of those cases and reviewing all of that since the last court date. I know your position, obviously, Mr. Kimmler, Mr. Nichols. What is the state's position?
Judge, after looking at those myself, I think we're in the Fifth Circuit case dealt with the underlying felony of being a simple possession of drugs. The Supreme Court ruling wasn't so much felon possession of firearm, but a firearm in the possession of a firearm by a drug user. So that was kind of the main theme under all those cases was simple possession, simple drug use does not equal dangerousness. In this instance, Mr. Glover's prior is for child endangerment. And while it is some years ago, on its face, that is it's reasonable to deduce that's a dangerous prior felony. He also has the intervening felon possession of a firearm in the years since that original conviction. So I think in this instance, the state can make a very clear argument that he's shown a history of dangerousness and that the prohibition on possessing a firearm by a felon should apply and that the motion to quash should be denied.
All right, thank you. Anything else to follow up?
Other than just, I think the inquiry is dangerousness, and obviously drug cases are a subset of dangerousness, lack of dangerousness, but I don't think the ruling is limited simply to drug cases. I think the court's research probably reflects that. The question is whether the underlying felony conviction of endangering a child rises to that level of dangerousness so as to preclude his ownership of firearms or possession of firearms. I would just note that at the time he pled to that, there was no DWI child passenger statute. And I think had that statute been available, that's probably what he would have pled to. And then you obviously wouldn't have the endangering language and the conviction itself. So that is something that I would ask the court just to note that should the case, just not to take notice of the fact that if the case were indicted today, it probably would not have been pled as an endangering child. It would have DWI child passenger, and whether DWI child passenger cases are inherently dangerous, I guess, is another inquiry as well.
So there's nothing at this time in these newer line of cases that is specific with regard to any other real underlying type of offense other than possession of a controlled substance or possession of a drug of some sort. And I'm not going to start going down the road, I think, of making those decisions unless it is real clear, I think, for whatever reason that underlying offense should not be included. And so I am going to deny the motion to quash, and we will get this case set back on the trial docket as quickly as we possibly can.
I think it's currently, it has a trial
Is it still already? Okay, it is. All right. And just also part of that finding that I'm making is based on the actual facts of the underlying case, regardless of whether or not it's an endangering a child or nowadays driving while intoxicated with a child passenger. I would think regardless, it's the same, that the facts of this case as reviewed with a young, I think it was a 9-month-old or 8-month-old sitting in the lap of the passenger in the front seat of the car. I think that in and of itself is dangerous, whether it's a DWI or an endangering a child, either way. So that is the basis of my findings. So we will move forward with trial at that next court date.
Sure.
All right.
Thank you, Your Honor.
You can, you're free to go, sir. I don't have Good morning. Reed Jacordi and Guillory.
Yes, ma'am.
And Mr. Guillory has two cases. 23 DCCR 1225 is a motion to revoke probation. Underlying offense is evading arrest or detention with the use of a vehicle. And then we've got 26 DCCR 0631, a new offense of evading arrest or detention with the use of a vehicle. And what is the announcement?
I reviewed the discovery in this case and discussed it with Mr. Guillory. He's advised that he did not commit the new offense, although the state's conveyed what I consider to be a reasonable offer to dispose of the NTRP in the new case. Since Mr. Guillory is maintaining that he's innocent of the new charge, I have to set it for hearing.
So I would,
Absolutely not true.
so we want to go through the motion then and go forward on that motion instead of the, let me get that pulled up. And are there any videos or anything that you need some time to watch?
No, I don't think from reading the file, there were some videos that identify the defendant. Or actually identify the person operating the motor vehicle.
Oh, okay. All right. Give me just a second to get that pulled up.
I do have some media on that, Judge, and I'll make sure that Mr. Kimler, if he indicates to the court that he is retained on that case, I will make sure he has access to discovery, and I'll make a copy of that.
I've got them on both cases.
Okay.
So if you'll make that request, Mr. Kimler, it sounds like there may be something that,
And also, Judge, at the appropriate time, if I might just ask the court some questions regarding the bond issues, I'd appreciate that.
Mr. Guillory, please raise your right hand. Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth?
Yes.
You can put your hand down, and will he waive the formal reading of the motion?
Well,
All right, Mr. Guillory, in cause number 23, DCCR 1225, I have a motion to revoke your unadjudicated probation. Shows that you were placed on probation January 6th of 2025 for the offense of evading arrest or detention with the use of a vehicle, and that was a 4-year deferred probation. Is that correct?
Yes,
It alleges that you violated your probation. Count 1 alleges that you committed the new offense of evading arrest or detention with the use of a vehicle, February 27th of 2026. And is that true or not true? Count 2 alleges that you failed to work faithfully at suitable employment and provide verification of that. Is that true or not true?
not true, because,
It's okay. I'll get the explanations later. I just need to know true or not true.
yes, ma'am.
Count 3 alleges that you failed to remain in Jefferson County as ordered and that you were in Harris County, February 7th of 2026. And is that true or not true? Count 4 alleges that you failed to provide and maintain an accurate residence address with probation officer. It says you reported your address at 2218 Rush Street, but identified your address at 2450 West Lucas to the Beaumont Police. Is that true or not true?
That's not true, because I had to change.
All right. Did you tell probation?
Yes, ma'am.
Okay. Count 5 alleges that you failed to provide documentation verifying the source and amount of your income, 2025 tax returns, etc. Is that true or not true?
That's true.
Count 6 alleges that you failed to provide verification of performing community service hours as required. Is that true or not true?
Not true.
Count 7 alleges that you were at a location other than your residence at approximately 11:20 p.m. on February 27th of 2026 in violation of your curfew. Is that true or not true?
Was dead.
February 27th of 2026.
it's not true.
Not true.
Okay. Count 8 alleges that you are behind in your court assessed fees as of April 20th of 2026 in the amount of $1,812. Is that true or not true?
True.
All right. Did you enter your pleas of true to counts 3, 5, and 8 freely and voluntarily?
Yes, ma'am.
And did you plead true to those counts because they're actually true?
Yes.
All right, then I'm going to find that you entered your pleas of true to counts 3, 5, and 8 freely and voluntarily. Find those counts true. Find sufficient evidence to find you guilty and revoke the probation, but I'm not going to do that. I'm going to reset the case for a hearing, and any discovery or any issues with regard to that new case get taken care of before then. And Ms. Malfino, do you anticipate that being, I guess, just one officer?
One officer and Miss Lopez.
All right, so we can just do it at 11, don't y'all
Yes.
think? No, just on a regular court date, but at 11, giving us about an hour. Okay. All right, we'll see you back then, and we'll get an updated pre-sentence report as well. All right.
So,
We need a fingerprint over here, please. Oh, wait, is there something else? I'm sorry.
No,
Come
I
back.
just was gonna let you know, I actually have one of those officers coming for a motion to suppress next week. I don't know if that will give Mr.
That's fine. We can do
time,
that.
but I'd be happy to do it. It's next Monday, the 13th at 1. We have a couple of those type of hearings.
That's fine.
I don't know that I can get an updated,
Okay, I just wanted to offer.
okay,
Same officer would be here.
it would be, okay, as the 1 o'clock. Let me look at that and make a notation on that, and I'll take a look at it after we get. You can? Okay, thank you.